Minnesota has a detailed and increasingly tenant-protective lease termination framework that landlords need to navigate carefully. The governing law is found in Minnesota Statutes Chapter 504B, which covers residential tenancies comprehensively, from notice requirements to eviction procedures to tenant remedies. If you manage rental property in Minnesota, precision matters because the courts here hold landlords to strict compliance. Let's start with no-cause termination. For month-to-month tenancies, Minnesota requires either party to provide written notice equal to the length of the rental period, which for a monthly tenancy means at least one full month's notice. The notice must be effective at the end of a rental period. So if rent is due on the 1st and you want the tenancy to end on the last day of March, you need to deliver notice before March 1st. However, and this is important, if the property is in a city or county that has enacted additional tenant protections, the notice period may be longer, or the landlord may need just cause to terminate. Minneapolis and St. Paul have both been active in tenant protection legislation, and landlords in the Twin Cities need to check local ordinances carefully. Minneapolis enacted a tenant protection ordinance that includes specific requirements around lease terminations, and St. Paul has implemented similar measures. These local rules can add requirements on top of what state law mandates. For fixed-term leases, the lease expires at the end of the agreed term. Minnesota law requires the landlord to provide notice of non-renewal. The specific period depends on the length of the tenancy and any applicable local ordinances. If the tenant remains after the lease expires and the landlord accepts rent, the tenancy converts to a month-to-month arrangement under the same terms. For week-to-week tenancies, 1 week's notice is required from either party. Now let's cover termination for cause. For non-payment of rent, Minnesota requires the landlord to provide a 14-day notice before filing for eviction. Under Section 504B.291, the landlord must deliver written notice giving the tenant 14 days to pay the rent owed. If the tenant pays the full amount within the 14-day window, the notice is satisfied and the tenancy continues. If the tenant doesn't pay, the landlord can file an eviction action, known in Minnesota as an unlawful detainer, in housing court or district court. Minnesota's 14-day non-payment window is longer than many states and reflects the legislature's emphasis on giving tenants adequate time to address payment issues before losing their housing. The notice must clearly state the amount owed and the deadline for payment. Here's a critical detail about Minnesota's non-payment process. The state has a statutory right of redemption that is among the strongest in the country. Under Section 504B.291, the tenant can pay the full amount of rent owed, plus any court costs and attorney's fees, at any time before the court issues a writ of recovery of premises. Any eviction will be stopped. This right of redemption can be exercised even after judgment has been entered against the tenant. However, if the tenant has exercised the right of redemption once before within the past 12 months, the right is extinguished for the remainder of that period. This limitation prevents chronic non-payers from using redemption repeatedly while still protecting tenants facing a one-time financial hardship. For lease violations other than non-payment, Minnesota's framework is less detailed at the state level than some states. The landlord must provide reasonable notice of the violation and give the tenant an opportunity to cure in most circumstances. The specific notice period depends on the nature of the violation, the terms of the lease, and any applicable local ordinances. For material breaches of the lease, meaning violations that substantially undermine the purpose of the rental agreement, the landlord can pursue eviction after providing notice and an opportunity to cure. If the tenant fails to cure within the notice period, the landlord files an unlawful detainer action. For serious violations, including criminal activity, drug-related offenses, and conduct that seriously endangers the safety of other residents, Minnesota provides expedited procedures. The landlord can file for eviction on a shortened timeline, and courts can schedule hearings quickly when the circumstances warrant it. Minnesota has specific statutory provisions addressing drug-related criminal activity. Under Section 504B.171, if a tenant, a member of the tenant's household, or a guest is involved in drug-related criminal activity on or near the premises, the landlord can terminate the lease and pursue eviction. The landlord doesn't need to wait for a criminal conviction. Evidence of the criminal activity is sufficient to support the eviction action. This provision was enacted to help landlords address drug activity quickly and protect other tenants. Minnesota also addresses situations involving violent criminal activity. If a tenant engages in behavior that creates an immediate threat to the safety of other residents, including assault, weapons offenses, or threats of violence, the landlord can seek emergency relief through the court, including an order requiring the tenant to vacate pending a full hearing. The eviction process in Minnesota goes through the housing court in Hennepin County, which includes Minneapolis, and through district court in other counties. The landlord files an eviction complaint along with proof that proper notice was served. The court schedules a hearing, typically within 7 to 14 days of filing. Minnesota's eviction process requires the landlord to follow precise procedural steps, and any deficiency in the notice or the filing can result in dismissal. Minnesota has a unique feature in its eviction process: the expungement of eviction records. Under Section 504B.345, tenants can petition the court to seal their eviction records in certain circumstances. This has become an increasingly important issue in Minnesota, and recent legislative changes have expanded the grounds for expungement. For landlords, this means that eviction filings carry additional considerations. A dismissed or resolved case may be expunged from the record, which affects how the eviction history appears in future tenant screening. If the court rules in the landlord's favor, a writ of recovery of premises is issued. The tenant then has a specific period, typically 24 hours, to vacate before the sheriff carries out the physical eviction. The overall timeline from filing to removal is approximately 3 to 5 weeks for uncontested cases in most Minnesota jurisdictions. Contested cases can take longer, particularly in Hennepin County, where the housing court handles a high volume of cases. On the tenant side, Minnesota provides robust grounds for early termination. If the landlord fails to maintain the property, as we covered in our Minnesota habitability video, the tenant has access to the powerful Tenant Remedies Action under Section 504B.395, which can result in rent reduction, court-ordered repairs, or lease termination. Active duty military members are protected by the Service Members Civil Relief Act and can terminate with 30 days' notice following deployment or permanent change of station orders. Minnesota provides comprehensive early termination rights for victims of domestic abuse, harassment, and sexual assault under Section 504B.206. A tenant who is a victim can terminate the lease by providing written notice along with qualifying documentation, which includes a valid order for protection, a no-contact order, a police report, or a signed statement from a qualified third party, such as a social worker, counselor, or domestic violence advocate. The tenant must provide at least 1 month's notice before the termination date, and the landlord cannot charge early termination fees or report the early termination as negative rental history. The tenant is responsible for rent through the termination date only. Minnesota's domestic violence termination provision is notable for how broadly it defines qualifying documentation. Unlike states that require a protective order or police report specifically, Minnesota allows a signed statement from a qualified professional, which significantly lowers the barrier for victims who may not have involved law enforcement or the court system. Minnesota also provides early termination rights for tenants who need to enter a care facility. Under Section 504B.205, a tenant who needs to move to a nursing home, assisted living facility, or other residential care setting can terminate with 2 months' notice. This provision protects elderly and disabled tenants who face unexpected health changes requiring a higher level of care. Minnesota has another unique early termination provision. Section 504B.206 allows tenants who have been the victim of a crime on the premises to terminate the lease early if the crime was reported to law enforcement. This goes beyond domestic violence and covers any qualifying criminal act that occurred at the rental property. Minnesota strictly prohibits self-help evictions. Under Section 504B.225, landlords cannot change locks, shut off utilities, remove doors or windows, remove the tenant's belongings, or take any action to force a tenant out. The penalties are substantial. The tenant can recover actual damages and up to $500 in statutory damages, plus attorney's fees. Courts in Minnesota enforce this prohibition vigorously, and a landlord who engages in self-help will face both financial penalties and severe credibility damage in any subsequent proceedings. Minnesota's anti-retaliation protections under Section 504B.441 are strong. Landlords cannot take adverse action against a tenant for making a good faith report about habitability issues, exercising their rights under the Tenant Remedies Statute, or participating in a tenant's organization. The presumption of retaliation applies for 90 days after the tenant's protected activity. One practical consideration for Minnesota landlords: the state requires specific language in residential leases regarding the tenant's rights. Under Section 504B.181, the lease must include certain disclosures about the tenant's rights and available resources. Failure to include required disclosures can affect the landlord's ability to enforce the lease in court. Making sure your lease template is current and compliant with Minnesota's requirements is essential. Minnesota requires landlords to return the security deposit within 21 days of the tenant vacating the property, or within 5 days if the tenant was in a building that was condemned. The landlord must provide an itemized statement of any deductions. If the landlord fails to return the deposit or provide the statement within the required period, they may be liable for the full amount of the deposit plus a penalty. Minnesota also requires landlords to pay interest on security deposits held for more than 1 year. The interest rate is set annually by the Commissioner of Commerce. For the complete guide to Minnesota lease termination laws, visit tenantscreeningbackgroundcheck.com and subscribe to our channel for every state in our series.